Gavin McEwan, Assessor, Bishop, Primus, members of Synod. When I was asked to speak to General Synod about charity governance and trusteeship, I suspect what those inviting me had in mind was training which I, with others, have been leading across the Diocese of Edinburgh to vestry members. And that training will continue this autumn and probably for years to come. I can see some faces from the Diocese of Edinburgh, people who have been to that training. I can see some people from the diocese who have not been to that training. You're very welcome. Please come. If you're not from the Diocese of Edinburgh, then you'll have had your tea, as we say. But we might invite you. Some of what I will say today, therefore, is a distillation, in essence, of some of that training with a few bits added. It will, of necessity, be a summary, because the training's a half day and I have about half an hour. I've tried to tailor this in such a way that it's focused on the church at all levels, but also some of this will be relevant to other charity trusteeships that you may have. And throughout, I'll talk quite a lot about us or we. I'm doing that on the basis that all of us have some kind of charity trusteeship role, probably almost entirely within the church, but many will have roles outside the church. So when I talk about us or we, I'm talking about us all with our charity trustee hats on. I thought it might be helpful just to say a few words, just for historical context, about how we've got here in terms of how charities are regulated in Scotland. Most of us in Synod will know about the Office of the Scottish Charity Regulator, or OSCR as we call it affectionately, perhaps slightly anthropomorphically. Several, if not all of us, should recognise the title of the Charities and Trustee Investment Scotland Act 2005. That's the governing legislation for charities in Scotland, and I'll talk about the 2005 Act a few more times in this session. But prior to 2005, charities were in fact registered in Scotland, but they were only registered with HM Revenue and Customs, or as it was then, the Board of Inland Revenue. The Revenue's Register of Charities became OSCR's initial Register of Charities, and it was from the Revenue list that the current register was built up. And by the way, some charities which are on the current OSCR register were grandfathered over from the Revenue list, and they have not been subject to any formal review by OSCR, other than through their annual returns and their annual accounts. Unless a charity has had an inquiry or an investigation or has actually updated its constitution, your constitution will not have been reviewed by OSCR. It's just a reminder that we, as charity trustees, have to update our own constitutions. OSCR doesn't have the resource to prompt us to do it. And charities were also regulated before OSCR came along, but they were regulated by a very small subsection of the Crown Office, which, as you probably know, is there to prosecute crime. And what happened in terms of regulation before OSCR was very definitely what we would think of as under-regulation. The system that we have now is still relatively light touch, especially compared to the much more interventionist Charity Commission in England and Wales, but it's better resourced and it's much more effective than what we had before. So the 2005 Act gave Scotland a regulator with more powers, more resource, more rigour when it comes to dealing with actual or perceived difficulties in the charity sector. And as well as a regulator and a register, and all the powers and procedures that go with that, the 2005 Act also gave us, for the first time, a codified set of charity trustee duties. And I want to spend a fair bit of time in this session looking at that. The charity trustee duties that we have in Scotland from the 2005 Act are not completely new. Most of them have existed in some shape or form as fiduciary duties, as duties owed by trustees generally. There have always been rules in some shape or form dealing with conflicts of interest, mostly all common law rules, and they have existed literally for centuries. So the 2005 Act is not presenting a completely new set of duties, but it is giving us a small codified set of duties, and it is pretty minimalist in what it says about how charity trustees should behave. So let's look at that. First, the role of charity trustees. Their role, according to the 2005 Act, is to control and manage the administration of a charity. In other words, the legal expectation is not that the charity trustees themselves will actually carry out the administration of the charity, but they will control and manage that administration. So what the law is really getting at here is setting strategy, maintaining an overview or oversight of a charity's affairs, bearing ultimate responsibility for the charity's affairs and activities. Now, that all rather assumes that a charity will have staff or volunteers who actually do the administering. And of course, we know in a church setting that that is not always the case. At charge level in particular, vestry members are frequently the doers and not just the overseers. They are the administrators and not just the strategy setters. So for us within the church, the proposed, or the supposed boundary rather, between control and management, what charity law thinks is the role of vestry members, and administration, what vestry members actually end up doing, is more than a little blurred. Now, that reference to control and management comes from the 2005 Act, and there is other guidance across the sector which builds on that role and looks at how a well-run charity should operate, and I would encourage you to seek out that guidance. The Scottish Episcopal Church also, though, adds to the role definition in the Code of Canons, particularly for vestry members. In Canon 60, it says that the vestry is to do two things. It is to cooperate with the rector. Some nervousness in the room there. And it is generally to assist the rector in all matters relating to the spiritual welfare of the congregation and the mission of the whole church. And there are provisions about managing property and so on, which you would expect. But that first part of Canon 60 is really important. Vestry members in our church are tasked with cooperating with their rector, generally assisting their rector, and that's focused on spiritual welfare in your own charge, but it's also focused on the mission of the entire church. And I suspect that many vestries do not think of their role in quite those terms, but these are our canonical obligations as vestry members. Now, I know, of course, that some charges will, from time to time, and perhaps for an extended period, not have a rector, but these are the standard expectations which General Synod has set in the Code of Canons for the behaviour of vestries. That's the role of charity trustees and the canonical role of vestry members. But what about the duties which are imposed on charity trustees? And this includes charity trustees across all levels of the church, so at charge level, at diocesan level, at provincial level. The 2005 Act says that the first and overarching duty is to act in the interests of the charity. Now, the Act says that charity trustees must act in the interests of the charity. So this is not guidance. It's not good practice. It's not a goal to aim for. This is a legally binding obligation to act in the interests of the charity. Now, the law does not expect us to act in the best interests of the charity. And it's in misunderstanding that duty that sometimes trustees feel exposed, or sometimes where third parties try to trip up charity trustees. The law does not expect charity trustees always to do the optimum. The law and OSCR knows that charity trustees are human. And the law and OSCR knows that humans make mistakes. Humans have always made mistakes. This is normal. And the law provides that sometimes a charity trustee who has breached their duties ought fairly to be excused. We are not expected as charity trustees to score 100% consistently, but provided we have acted in the charity's interests, which is different from the best interests, if we acted in the charity's interests, then we will have met our overarching duty. Charity trustees are also to seek in good faith to ensure that their charity acts in a manner which is consistent with the charity's purposes. Now, charity trustees can only do that if they understand what their purposes are. And for many charity trustees, that means that they ought to be reading their own constitution a bit more regularly so that they can focus properly on what their purposes are. Now, this bit is perhaps easier for the church to get right, because across the entire province, we are all focused on the advancement of religion and the general provision of public benefit. So for us, it's easy to know what our purpose broadly is. Other charities have much more complicated purposes, and the position is maybe not as clear-cut. Charity trustees are expected to act with the relevant degree of care and diligence. Now, the standard here which is to be met is the care and diligence that it's reasonable to expect of someone who's looking after someone else's property. At its most basic, the way to consider that standard of care and diligence is to park what you would do with your own assets, your own affairs, protecting your own reputation, if you make any effort to do so, and instead to focus on the charity's assets, affairs, and reputation as if they were someone else's, which we only have custody of for a limited time and which we will hand on to custodians after us. And it's obvious, I think, that the care you need to bring to looking after someone else's money and affairs is a higher degree of care than you are expected to apply to your own affairs. You can be as reckless as you like with your own property and person, but the law expects you to act more responsibly with the affairs of others. The 2005 Act then goes on to deal with managing conflicts of interest, and it provides a mechanism for dealing with conflicts, namely to put the interests of the charity first. Really simple. But where you can't do that, because some other duty prevents you from putting the interests of the charity first, then you have to declare the conflict of interest and refrain from deliberations or decision-making on the matter where the conflict exists. It is not always possible completely to escape conflicts of interest, but managing them as best you can is the legal expectation. Now, I could say more about duties in terms of wider compliance with the 2005 Act and managing misconduct, but I want to say a little bit how these legal duties are enforced before I move on. OSCR will, of course, seek to ensure that charity trustees are behaving in line with their duties, but they cannot realistically do that day in, day out across the entire charity sector. It is simply impossible for OSCR to have that degree of oversight. So enforcement of the duties really begins with each individual charity trustee board. Collectively, each board of trustees has a duty to ensure that all of their number are carrying out their duties and to seek to correct any mistakes which may have been made along the way. OSCR will intervene if they think that something may have gone seriously wrong, especially if it puts charity assets at risk. But when OSCR does that, it's more often than not looking at that overarching duty to act in the interests of the charity and to see if that duty has been fulfilled. Yes, there are sometimes problems about conflicts of interest. Yes, sometimes there are shortcomings in the care and diligence trustees have applied. Sometimes charities do act out with their purposes, usually by mistake. But the most common issue is usually whether charity trustees have acted in the charity's interests. Now, OSCR, you will not be surprised to know, is not all-seeing and all-knowing. It will normally only ever be able to work with information which is available to it if it's carrying out some kind of regulatory investigation. So that might be minutes of meetings, policy documents, papers prepared for trustees to consider and approve. And they may add to that by interviewing individual charity trustees in some cases, but they won't always do that. But even armed with all of that information, OSCR can't, in all fairness, second guess on every occasion what the charity trustees ought to have done each time they make a decision. So part of the enforcement of legal duties is actually fulfilled through our own proper decision making and the recording of decisions clearly and properly, and crucially, recording the reasons and justification for major decisions that we take as trustees. You'll remember in arithmetic exams or maths exams, even if you got the wrong answer, you got marks for your workings. The same applies here. Record your decisions fully and show your workings. If you've followed process properly, you've come up with a reasoned decision, and you can show that reasoned decision and why you felt at the time it was in the interest of the charity, then you will, in almost every case, have fulfilled your legal duty. So it's the proper process, the proper discipline of proper decision making and proper record keeping, which helps towards our own self-enforcement, if you like, of the charity trustees the charity trustee duties that we're exposed to. Now, we are aware in the Church that we are bound both by the Code of Canons and by charity law. And there's sometimes confusion or a misunderstanding about which takes precedence. The duties I've just spoken about are binding under the law of Scotland, but that alone is not the starting point. OSCR emphasises that charities must abide by their constitution. That's their governing document. This is your internal law, in other words. So charity trustees are responsible for ensuring that their charity, first of all, adheres to its constitution. That means that charity trustees must fulfil their duties under their own internal law, as well as under charity law. And where duties overlap, trustees have to comply with whichever are the more stringent requirements. Now, for a vestry in the Scottish Episcopal Church, its constitution is really its own constitution plus the Code of Canons. For a diocese, the constitution is typically an administrative scheme, or it may be called by a different name, plus the Code of Canons. At provincial level, the Code of Canons is the constitution, and to these we add the digest of resolutions. If a charity's constitution is permissive, but charity law on the same point is more strict, then charity trustees have to act in the space where the constitution and charity law converge. If a charity's constitution is more strict than charity law, the constitutional restrictions apply. There are very limited times when a restriction in a constitution will be overturned by charity law. Mostly it will happen where OSCR has given a specific direction to a charity to do some positive act, and that's a new power which only came into effect last April 2024, that is. But aside from that, OSCR has no substantial ability to force a charity to act outside of the terms of its constitution. So think of your constitution as your internal law. You have to abide by that just as much as you have to abide by charity law. They sit side by side. As well as that inability to force a charity to act out with its constitution, OSCR has also made clear in its own guidance that there are some matters that it will not regulate. OSCR says, we act in the interest of the public as a whole and not on behalf of individuals or groups. Not all issues are ones that we can deal with. This could be because the charity trustees are the people that need to deal with the matter because it is their job to run the charity, or we do not have the legal authority to deal with the issue. Now, OSCR gives some specific examples of things that it will not regulate. It will not intervene in employment law problems, for example. It will expect a charity to deal with employment law problems, but OSCR will not fix those problems for you. If you need external advice, OSCR will not give you that advice. You will need to source it, probably from an employment lawyer, from ACAS, from whoever else you might want to approach. It will not step in to help you chase debts or recover assets, but OSCR will expect you to have taken steps to do those things. OSCR will not help you to do them by itself. It will not step in to regulate that area. OSCR is especially clear when it comes to disagreements that it will not get involved. We know that humans sometimes disagree, and sometimes they disagree badly. This is normal. OSCR's role isn't to resolve disputes between individuals and charities. These are OSCR's own words. Nor is it OSCR's role to come to a concluded view on who is right or wrong. We expect charity trustees to work together to resolve such disputes wherever possible, seeking advice and using mediation services if necessary. Again, OSCR's own words. So if after raising a matter with a charity's trustees, you're still unhappy with the outcome, it's still not for OSCR to deal with. OSCR says decisions taken by charity trustees that are within the powers set out in the charity's constitution and in line with their legal duties as charity trustees cannot be overruled by OSCR, even where they are unpopular. And again, OSCR says that where a charity's followed its processes and procedures in its constitution, then whether you agree with the charity trustees' choices or not, we cannot take action. Now, many members of the public, many charity trustees, are disappointed that that is OSCR's stance. I have lots of clients who think that this is a scandal, that OSCR has no teeth, and actually OSCR should be much more brutal in how it deals with wayward trustees. Not all of my clients are quite as draconian. But it's simply not what OSCR was set up to do. So disputes and disagreements are for charity trustees to fix by mediation if necessary, as OSCR says. OSCR will not take sides in a disagreement. Now, running a charity is a risky business. Life is a risky business. Almost everything we do carries some kind of risk. Risk is largely unavoidable. And we know that one of our key duties is to treat a charity's assets and affairs as if they are someone else's. So that means that we will, or at least should, exercise more care and less risk when acting as charity trustees. But there will still be risk. Risk matters because when things go seriously wrong, there may be liability. Now, in the Scottish Episcopal Church, the General Synod, all 7 dioceses, and almost every charge, with a few exceptions, are unincorporated bodies. The impact of that is that the charity trustees at each level of the church carry personal liability when things go very badly wrong. And this is the slightly scary bit. And that liability is unlimited. Now, it is absolutely crucial that we don't lose sight of the protections which exist. All congregations have insurance, or at least they ought to have. Most congregations are not doing things week by week which are inherently high risk. Humans are normally pretty good at spotting risks and avoiding them, or taking steps to protect against them. It's instinctive, and it should be part of our collective behaviour anyway as charity trustees. And there is lots of guidance and lots of resource available to support congregations who are undertaking major projects which might carry a risk. The fact is that for the most part, being a vestry member or a charity trustee of any other charity is really as risky as life in general. If we feel apprehensive about risk and liability, then it's helpful to keep in mind that humans generally are usually fairly risk averse, but it helps to channel any apprehensiveness into good behaviours as charity trustees. So we should use our aversion to risk as an encouragement to adhere to our duties as trustees. By doing that, you can limit your exposure to risk, and you can limit and possibly even eliminate any liability that you would ever face personally. If a charity simply has no stomach for risk at all, or if a charity is engaging in activity which is high risk and about which it feels very exposed, then there are limited liability forms of constitution which are available. The form created especially for Scottish charities is called a Scottish Charitable Incorporated Organisation, or SCIO, S-C-I-O. A few charges in the SEC are SCIOs, and model SCIO constitutions will soon be available from the province for people to use. You should not assume that a SCIO is the right option for every charge in the province. It may not be. And converting to a SCIO can be hard work. There's more to the process than meets the eye, but it's an option, and it's an option which, in due course, it will be right for at least some charges to think about. So risk and liability is not something to panic about. It's something which I think we should have a slightly healthy sense of fear about, and we should embrace that fear and use it to drive good trustee behaviours. Now, I want to round off by looking at some charity law reform which has just come into effect, or which is about to come into effect. And I've particularly chosen parts of law reform which I think are more relevant to the Church. On 1st of April last year, OSCR gained a new power to remove from the Scottish Charity Register any charity which fails to lodge their annual accounts and also fails to engage with OSCR about that failure. This is a one strike and you're out approach. One set of accounts not lodged and you could be removed from the charity register. And already OSCR has removed hundreds of charities from the register under these provisions. So you need to lodge your accounts each year, and if you are late in doing so, and there may be good reasons for that, you must communicate with OSCR to explain why. As long as you're engaging with OSCR, you will not be removed from the register, but you need to make sure you actually engage with the regulator when you're not able to lodge your accounts on time, or you risk losing your charity status. From the 1st of October last year, there's been a list maintained by OSCR of people who have been disqualified by the Court of Session from serving as a charity trustee. And that list is open to the public, and it's searchable on the OSCR website. And it's worth using that tool if you're in any doubt about whether someone is able to serve as a charity trustee, or perhaps even just as general due diligence when you take on a new trustee. There are about 184,000 charity trustees in Scotland. It's a huge number of people who volunteer as charity trustees. Only 43 people have been disqualified by the Court of Session. And that tends to suggest that it really is only in the most serious cases that disqualification will arise. From this summer, the automatic disqualification rules, which are different from being disqualified by the court, will be extended, and I'll come back to that in a second, just as I finish. But around the end of this calendar year, and the precise date has not been announced yet by the Scottish Government, there will be, in terms of other law reforms, a public-facing register of charity trustees on the OSCR website, and that will make the identity of trustees much more visible to the general public, and that will include all of our charges. The list will be a static list, and it will be charity specific. In England and Wales, you can click on a trustee's name, on the Charity Commission website, and you'll see a list of all the other charities which that person is a trustee of. That will not be possible in Scotland. Also, from the end of this calendar year, OSCR will start to publish charity accounts in unredacted form. So this means that the entire content of every charity's accounts will be visible to the public. I know some charities already publish their accounts anyway, so they're very visible. Not everyone does. At present, OSCR redacts names of individuals anywhere in a set of accounts, and it doesn't publish all charity accounts anyway at present, but that will stop, and all charities will have their accounts published. The intention is that OSCR will start to build up and display on its website 5 years of accounts at any one time for every charity, and we expect that to begin in 2025-26 and then build up over the 4 succeeding years from there. If there are people that you name in your accounts and you don't want to name them, then you need to think carefully about how the content of your accounts are framed, and now is the time to start thinking about that. Don't forget that charity trustees will almost always have to be named in the charity accounts. There are very limited reasons for excluding trustees' names. But for anyone else that you might want to mention, key donors, key supporters, volunteers, think carefully about whether you want to include those names or not, because they will become much more visible to the public. So last of all, to finish off, and as I mentioned a moment ago, the automatic disqualification rules for charity trustees are about to be expanded this summer. At present, a person is automatically disqualified from being a charity trustee if they are bankrupt, if they have committed certain offences of dishonesty, and in some other circumstances. Those rules will be extended to include a much wider range of criminal offences, including bribery, terrorism, money laundering, and offences which involve entry onto the sex offenders register. If a charity has a charity trustee that falls into one of those expanded range of circumstances, they will be unable to continue to act as a trustee once the rules are brought into effect. And if they continue to act even though they're disqualified, they commit a criminal offence. Not only that, those same rules will also extend from this summer, for the first time, to people with senior management functions in a charity, whether paid or volunteers. And OSCR has published updated guidance very recently on how that looks and how it will be enforced. I suspect, for the most part, for charges in the SEC, the senior managers are really the rector and the treasurer. Those are the people who fit most neatly into OSCR's guidance. And as the rector and the treasurer are normally also anyway members of vestry, so they're already charity trustees, they're covered by the rules anyway. But you can see that in other charities where the staff is completely different from the charity trustees, this expansion of the rules will have a serious effect, potentially, for any team member, any senior management team member who has fallen into one of these categories and is automatically disqualified. So it's worth reviewing the guidance and considering how your charge may be affected, if at all. I said the rules are to take effect this summer. There is no indication so far of a precise date, but the Scottish Government takes a very generous approach to the definition of summer, broadly in line with when the clocks change. And speaking of clocks, I think at that stage I should stop. But I'm very happy to respond to any comments or questions, Bishop.